Today is mostly Michelle, and Michelle's going to talk to us about estate planning 1A, essential documents that if you don't have, you really should have. For some of you, this will be redundant, but for others, pay close attention. So without further ado, Michelle.
Thank you so much. So in times of crisis and uncertainty, as we're dealing with right now with COVID-19 this year, as well as the fires in California, it's really more important than ever to have your estate planning documents in place. And having the necessary estate planning documents will not only help others to handle your affairs, but it helps your loved ones navigate through turbulent situations. So not to mention that without proper estate planning documents, your wishes may not be carried out and the state may make those decisions for you. So while we do not have the legal capacity to implement estate plans, we can certainly discuss your estate planning strategies and your desires and make sure that they are consistent with your objectives and that they follow your retirement plan. So today we thought we'd talk about the most important estate planning documents that everyone should have. And the first thing is a financial power of attorney. A financial power of attorney appoints an agent to manage your financial and legal affairs in the event that you're no longer capable of managing them yourself, such as if you become temporarily or permanently disabled. There are 4 main types of powers of attorney, and it's really important to understand the differences. If you have a power of attorney but are unsure as to the type that you have, I strongly encourage you to check. On our website, we have a checklist that you can download that will help explain the different types of power of attorneys and to document what you have. Similar to a financial power of attorney is a power of attorney for healthcare. If you become incapacitated, hospitals and medical providers will require a surrogate decision maker to exercise medical decision-making authority. And a power of attorney for healthcare allows you to designate a healthcare agent who you believe is best suited to make these types of decisions. A living will records your instructions concerning your healthcare wishes should you become seriously ill and assists your agent and others to carry out your wishes. In California, we have what's called an advanced healthcare directive, and that covers both. Next is a will. A will is necessary to manage and distribute a person's estate after they pass. And this includes naming appropriate beneficiaries and designating executors and other fiduciaries to carry out the terms of the will. A will provides a basic level of protection to you, your spouse, and loved ones, and avoids unnecessary expenses for your estate. So a will, a financial power of attorney, and a healthcare power of attorney provide a basic level of protection in the event of an unexpected illness or injury. But in some cases, more sophisticated estate planning documents, including trusts, are needed to accomplish your overall goals. So we're going to cover 2 that are most frequently used. The first one is a revocable living trust. And this is a legal entity that you create while you're alive to own property, such as your house and financial assets. Property that passes through a living trust is not subject to probate, and unlike property that is simply listed in your will, this kind of trust can be changed at any time. It can help preserve your privacy and may reduce probate and administrative costs. It can also be used to help you protect and manage your assets if you become incapacitated. If you can no longer handle your own affairs, your trustee or your successor trustee will step in and manage your property per your wishes. It's important to review the information in your trust from time to time for changes that may have become outdated or irrelevant. For instance, if you created your trust more than 15 or 20 years ago, you may want to review it due to changes in the federal estate tax exemption when your trust was created. If you have questions about this, please reach out to your estate attorney or contact us to discuss in further detail. An irrevocable trust, such as a bypass, credit, or B trust, this type of trust, the surviving spouse has limited control over assets. The surviving spouse is entitled to all income and can access principal for health, education, maintenance, and support. A separate tax ID number must be obtained and a separate tax return must be prepared. Assets are not included in surviving spouse's estate, and there is no step-up in cost basis upon a survivor's death. These were used more frequently before the increase in the federal estate tax exemption. Lastly, it's important to review your accounts that have beneficiary designations. This includes retirement accounts, such as individual retirement accounts, which include traditional IRAs and Roth IRAs, or your employer retirement accounts, such as 401ks, 403bs, 457s, as well as taxable accounts, such as transfer on death, also called TOD, or payable on death, POD. And don't forget those insurance policies as well. Review your beneficiaries periodically to ensure the beneficiary information is correct, and don't forget to include contingent beneficiary information. With the recent passage of the Secure Act, you'll also want to review if you have a trust listed as your beneficiary. Changes in the Act may have a significant impact on those who designate a trust as the beneficiary, so it's important that you review if doing so will still meet your original objectives. We've also created a really helpful estate plan checklist, and this reviews all of the information we've discussed today, plus some additional resources. You can download it from our website or from our YouTube channel. And we have a secure client portal where you can upload and store all of this information in a safe and secure location, and it will be convenient for you or your loved ones to access at a later date. So for our clients, this is available to them at no charge for the service. So I know we've gone through this pretty fast, but I just thought it was important to include those most important estate planning documents that everyone should have. If you have any questions, we're always here to discuss and to review what you currently have on file.
Excellent information. Thank you, Michelle.
You're welcome. Take care.
Yep, take care.
Bye-bye.